Hello, my name is John Milburn. Today I'd like to speak to you in relation to Chapter 5 of Jerry Bates' publication Environmental Law in Australia. Chapter 5 is an important chapter. It deals with the issue of federal governance and environment protection. It is in three parts. Part A deals with Commonwealth powers generally. Part B talks about state powers. And Part C talks about the leading instance of legislation at a Commonwealth level, which is the Environment Protection Biodiversity Conservation Act, or EPBCA. So let's begin that commentary. Australia is a federation. It has 6 states, of course, and 2 territories, and there is the National Parliament, Commonwealth. The Commonwealth Parliament has no direct legislative power in relation to environment. When the Constitution was enacted in 1900, environmental law was not an issue and would not have been of concern to those parties who legislated and provided for the Constitution. And as you recall from earlier talks, the Commonwealth government only derives its power in relation to what is conferred upon it via the Constitution. So when it comes to dealing with environmental law, that is parliamentary environmental law at a Commonwealth level, the Commonwealth has a very basic problem. It has no power conferred to it. Since the only matters which are conferred upon the Commonwealth where they have exclusive jurisdiction are limited, and where it has powers generally are specifically stated, the Commonwealth needs to find its power to make laws in relation to the environment from somewhere. Now, firstly, the exclusive powers which the Commonwealth does have. Section 52, that provides that the Commonwealth has power to make laws in relation to Commonwealth places and territories. Section 90 provides that the Commonwealth has power to make laws in relation to taxation, duties and excise. And the Commonwealth government has, in addition to that, power to make laws in relation to those things which are set out in Section 51 of the Constitution. In the event that the Commonwealth government has power to make laws in conjunction with, or if you like, in relation to the same areas of interest as states, then in fact all of those things which are in Section 51 fall into that category. It is the Commonwealth legislation which will take precedent where there is a conflict. So if we look at Section 51, there's no power for the Commonwealth to make laws in relation to the environment. And there are a wide-ranging set of activities which are noted, and in the 80s there was a raft of cases where there were constitutional challenges in relation to the laws that the Commonwealth were purporting to make, which were said to be beyond its power under Section 51. Fortunately, a lot of those cases the incidence of those sorts of challenges has decreased dramatically since the 80s. All right, so what happened is that during the 80s, the Commonwealth found itself successfully litigating most of those High Court challenges, and the states came to the realisation that they will need to work with rather than conflict with the Commonwealth government. So the Commonwealth is able to make certain powers that are environmental in nature as a result of relying upon other specific powers. For example, the Commonwealth Constitution, Section 51, subsection I, allows the Commonwealth to make powers in relation or laws in relation to trade and commerce. So that can be used in some instances to create laws which have an environmental flavour about them. The example in Bates is the Murphy-Ors decision. It's Murphy-Ors against the Commonwealth, 1976, and in that case the High Court upheld a challenge against legislation made by the Commonwealth to refuse to grant export approval for mineral sands on Fraser Island, and that was based on environmental and social grounds. The High Court said it is within the Commonwealth's trade and commerce power to enable those laws to be made even though they may have been made on environmental grounds. Another power is external affairs. So the Commonwealth has power to make laws in relation to international treaties. As we discussed in earlier talks, international treaties are not ratified by the Parliament itself, but rather by the government of the day at an administrative level. But the external powers laws or external affairs laws can sometimes have an environmental flavour. So, for example, in the Tasmanian Dam case, which is 1983, the High Court determined that the Commonwealth was able to validly enact domestic legislation in relation to external affairs, even though the legislation related to what was intended to be done by the Commonwealth in the Tasmanian Dam instance. The High Court said, look, the subject matter of the legislation was of international concern. It was therefore able to be made by the Commonwealth Government because the Commonwealth Government had power to enact laws in relation to external affairs. Another example is the corporation's power. So Section 51, subsection 20 of the Constitution provides that the Commonwealth may make legislation in relation to foreign corporations or trading or financial corporations. And it is clear since that Tasmanian Dam case that the power conferred upon the Commonwealth is not confined to merely regulating the trading activities of trading corporations. So the scope of the power in relation to corporations is very significant. The Commonwealth can also rely upon its power to make laws in relation to financial powers, taxation, acquisition of property on just terms. So these are other instances of specific powers referred to in the Constitution that can be relied upon by the Commonwealth to make laws that are, if you like, ostensibly environmental in nature. All right, I would like to just talk now briefly about this concept of acquisition of property. We touched on it in an earlier talk. It's an important area, and the Constitution provides, as we know, that the Commonwealth is able to make laws for the acquisition of property, provided it does so on just terms. And that's Constitution's 51, subsection 31. In Newcrest Mining, Western Australia against the Commonwealth from 1997, the High Court remarked in that case that the provision was a protection against the arbitrary and uncompensated deprivation of property. We talked about the concept of property in Chapter 3, and that was particularly in the context of property versus permissive rights such as licenses. So in the context of what we're talking about now, and this is Commonwealth governance, in acquiring property, we have to make the distinction between what is an acquisition of property versus a mere sterilisation or an extinguishment or a deprivation or a modification or a restriction of certain activities which might be done through licensing. So the question is, what is defined as property? Now, for a good example, have a look at the Commonwealth against WMC Resources. It's a 1998 High Court decision. In that case, the respondent was granted a statutory permit to explore for petroleum in an area that was subject of a dispute. Now, that dispute was eventually settled and the Petroleum Act of 1990 was enacted. But the provisions of the Act effectively abrogated the rights of exploration conferred upon the earlier permit. The High Court interpreted the conferment of the permit as, in that case, conferring a right of property that had subsequently been extinguished. And the point is that few corporations engaged in that business would invest the large amounts of capital required if, upon discovery of the petroleum, the government could simply thank them for their efforts and then divest themselves of the licence. And the commentary in that regard is from Justice Kirby at paragraph 222 of the case. However, compensation will only be payable if the property is acquired. If it's a mere extinguishment or sterilisation of a property, then there is not necessarily going to be an acquisition. Have a look at the case of Mutual Pools against the Commonwealth, which is a 1994 High Court decision. And in that case, the justices in the majority remarked that to constitute an acquisition, there must be obtaining at least some identifiable benefit or advantage. Now, if you merely sterilise a particular land use, that doesn't necessarily amount to an acquisition. A majority of the court decided that the statutory modification or extinguishment in relation to things which were being done by the Commonwealth does not necessarily provide a reciprocal benefit to another party. So therefore, if there's no benefit conferred upon the Commonwealth, how could there possibly be an acquisition of property? Again, in the Commonwealth against Tasmania, that is the Tasmanian Dam case from 1983, Tasmania argued that because the Commonwealth had passed legislation forbidding the construction of a hydroelectric dam, then the Commonwealth had in fact acquired property. The High Court rejected that argument and said, look, all we have here is a sterilisation of a particular form of use. That doesn't necessarily prohibit other uses to which the property might be put, and therefore there is no acquisition. However, in Newcrest Mining against the Commonwealth from 1997, the effective termination of a right to mine was considered to be an acquisition of property. Now, although that case has been criticised, it is nevertheless consistent with the Tasmanian Dam case because in Newcrest there was no other form of land use open to the plaintiff following the sterilisation of that particular form of land use. It's a grey area and it makes it difficult to necessarily state with certainty how a case might be decided in the future, but I think it's important that you consider from what we've discussed whether the particular land has some use other than that which was prohibited as a result of the executive or administrative intervention through licensing denial. All right. There is the argument that Section 51, subsection 31 could be triggered, and that is the on just terms provisions, if the Commonwealth financial assistance legislation subsequently is used to enable a state government to acquire property otherwise than on just terms. So in other words, the just terms provisions relate to the Commonwealth. The question is raised, what if the Commonwealth provides money to the states to acquire property? Are the states then bound by that same provision? And I guess it's an arguable case. All right, so I mentioned that in Chapter 5 there are three parts. The first part deals with the Commonwealth powers and the Commonwealth powers and laws which are really reflected in Section 51 of the Constitution. Let's move on now to the second part of the commentary in Bates, which deals with state legislative powers in relation to the environment. So the states retain power enjoyed at the time of federation to make laws for the peace, good order, and good government of the state, subject only to the limitations imposed in the Constitution. Now, as mentioned, there are only a limited number of exclusive jurisdictions conferred upon the Commonwealth. Section 52, which relates to Commonwealth places. Section 90, which relates to Commonwealth having exclusive laws to make rules in relation to customs and duties. Section 92, which deals with trade within the Commonwealth being free. And Section 109, which says that if there's an inconsistency between the laws, then the Commonwealth will prevail. Apart from that, the states do have full power, albeit in many instances concurrent with the Commonwealth to make laws. So what that means is, from an environmental perspective, we may have states and Commonwealths purporting to make laws in relation to environmental law issues, and we need to sort out essentially to what degree do the states really have that power to make the laws. Bearing in mind, as indicated, that where there's an inconsistency, the Commonwealth will apply. All right, now, from a financial perspective, states do provide financial incentives for environmentally friendly behaviour within the limits of their own revenue-raising power. And they can often do that through statutory schemes. And some of those schemes might be, in fact, funded through the Commonwealth government. I talked about the Commonwealth having jurisdiction to make laws in relation to Commonwealth places. There are some exceptions to that, and generally speaking, those laws, state laws which relate to environmental protection and planning, will generally not have application unless those laws are said to be conferred with the, I suppose, the good grace and the permission, if you like, of the Commonwealth. Right, let's move ahead. We talked about the Commonwealth involvement in the Tasmanian Dam case, and there are a number of discretions which apply in certain circumstances. Let's say, for example, Section 10 of the Environment Protection and Biodiversity Conservation Act declares that the Act is not intended to exclude or limit the concurrent operation of any state law. So that's an instance where the Commonwealth can make it clear that it will allow the states to make laws, but sometimes the Commonwealth law is said to cover the field. So it was held, for example, that the environmental assessment provisions of the Environment Planning and Assessment Act in New South Wales 1979 did not apply to Federal Airports Corporation. That would only have been allowed if the Commonwealth government specifically stated that the state has power to make laws in relation to it. I should mention that COAG was created to create some certainty in relation to the way in which the Commonwealth and the state laws work in conjunction with each other. So the the Council of Australian Governments drew up a draft agreement, and in that agreement there are commitments made by the state and Commonwealth agencies to work cooperatively with each other in relation to environmental law. And so we call that, if you like, cooperative federalism. And it all flows back to the fact that in the 1980s, the states were being beaten consistently in High Court challenges. So rather than litigate against each other, the states and federals tried to sort things out and come to these cooperative solutions that relate to environmental problems wherever possible. Now, the states argued that the Commonwealth takes power, it must also accept responsibility financially for compensation wherever relevant. And that's something which is particularly important when it comes to the acquisition of properties. All right, well, that's all I propose to talk about in relation to state law. The third and final part of the commentary in relation to Chapter 5 deals with the Environment Protection and Biodiversity Conservation Act of 1999. EPBCA, which is the lead act for the Commonwealth, it's something that you should look at. That act came into existence after a decade of debate about what should be the Commonwealth's legitimate role in dealing with environment protection. After all, in the 80s, everything was being challenged by the states. So EPBCA concentrates on, to quote, matters of national environmental significance, which were flagged in the COAG Agreement of 1997. Some examples of that are Ramsar wetlands, issues to do with Commonwealth land, Great Barrier Reef, etc. The Commonwealth may be interested in actions that might affect matters of national environmental significance or conducted by Commonwealth agencies. So when we talk about national environmental significance, one example is, is land clearing, and that is linked to biodiversity, salinity, water quality, and that's recognised by Australian governments as having significant national concern. So therefore, those types of issues can be the subject of administrative action through the Commonwealth by implementing the EPBCA in that instance. Actions which, if undertaken without approval under the Act, would be prohibited are known as controlled actions. And a person must not take a controlled action unless they receive approval under the Act. Prohibited actions are those that would or likely have significant impacts on matters of national environmental significance. And the test of significant impact is whether or not an action is a controlled action. So it's a little circular. Have a read of that commentary in Bates to get a better understanding. Now, the Federal Minister must determine whether the action is a controlled action. And if so, which provisions are the controlling provisions? If the action is determined to be a controlled action, then relevant impacts, which is past, future, and probable impacts, must be assessed by the methods which are set out in the Act. Now, importantly, when it comes to coming to a determination about controlled actions, there are bilateral agreements which need to be considered. And a bilateral agreement is an agreement between the Commonwealth or a state, or Commonwealth or a territory, where there is effectively an agreement to avoid or minimise duplication of environmental assessment and approval processes. So in deciding or not whether to take action and what conditions that might apply to that approval, the Minister must take into account matters that are protected by a controlling provision for the matter, and also social and economic matters. All right, so we've reached the end of my commentary in relation to Chapter 5, but I'll just say this, that in making these sorts of decisions, the Minister is also instructed to take into account the precautionary principle to the extent that that is consistent with other provisions of the Act. Thank you very much for your attendance.